Thank you, everyone. Please be seated. We are here today for the submission of 4 cases. The case of State versus Uranga is hereby submitted without oral argument. And the case of State versus Halleck is also submitted without oral argument. Our first oral argument today is State versus Brown. It looks like the parties are ready. Am I pronouncing it correct? Is it Jennisch? Okay, Ms. Jennisch, you may begin. Oh, wait a minute. Stop right there. Sit down. High school class here, Audubon. Go Wheelers. We have a high school class here, which my colleagues, they actually alerted me because they know what I do, and they complain about it, but obviously they love it. All of us, of course, not only graduated from a law school, we graduated from a college, and we all graduated from a high school. And we just want you to know that we remember being at that point in our lives, appreciate you taking the time out of your schedules to come see what we do. And I am a Harlan Cyclone. I know you know where I live, because I certainly know where you live. And when I was a trial court judge, I was in your county a lot. So I know exactly where Albert the Bull is. We'll go now in order of seniority, and they're going to tell you where they went to high school and what their mascot is. And by the way, lawyers, you have to too. I think Mr. Sloven's done this before.
Hi, Tom Waterman. Grew up in Bettendorf, attended Bettendorf High School. The Bulldogs. Yep.
Ed Mansfield. I grew up in Lexington, Massachusetts, and went to Lexington High School. The mascot is the Minuteman. If you follow the Revolutionary War, if you watched Ken Burns' series, you might understand why.
Christopher McDonald. I went to Des Moines Lincoln High School. The nickname is the Rail Splitters, and the mascot was Abe Lincoln carrying an axe.
Hi, I'm Dana Oxley. I went to what was then Greenfield High School. We're the Greenfield Tigers. It is now Nottoway Valley, and I believe they're the Wolverines.
Good afternoon. I'm Matt McDermott. I went to Kemper Catholic in Carroll. We are the Knights. And I was at your school last fall, so good to see you again.
Hi, I'm David May. I grew up in Kirksville, Missouri, and went to Kirksville High School, and we are the Tigers.
All right, now, Ms. Jennisch, you may approach, and when you need to tell us where you went to high school and what your mascot was.
I grew up in Des Moines, West Des Moines actually, but I went to high school on the East Coast. I went to Phillips Academy in Andover, Massachusetts, and as far as the mascot is, I don't remember. I just know we just said, "Go Big Blue." So that's a color.
Smurf, maybe. Go ahead.
I'm representing Mr. Brown in this matter as the appellant, and he is appealing from his conviction for attempted enticement in violation of Iowa Code Section 10.10. I've raised 2 issues on appeal, the first being a jury instruction error, and the second being a sufficiency argument, and both are very related. But I'm going to just start with the instructional error. We've alleged that the instruction, the elements are, according to the jury instruction, the Marshall instruction, is that the defendants entice the child with the intent to commit an illegal act. In this case, she is 13 years old. That's not in question. At the motion for judgment of acquittal discussion, this is when it first came up, the parties talked about the fact that a legal act within the context of this statute is not defined, and proposed, first of all, and suggested that there was no indication of any sexual intent or anything of that nature, but also broadly that there's just no guidance given to the jury as far as what the definition of an illegal act is.
Wrong. At the trial court, wasn't the argument that you need to give the jury some idea of what act you're saying is illegal, whereas on appeal, it seems to be the argument is that the definition by the judge should have, and it was error not to talk that it was an illegal sex act. Aren't you taking that a little different than what the trial court said, or what was done at the trial court level?
We're just expanding it. It's not any, we're not creating a different argument. I think under, the basic premise is that the jury doesn't know what the illegal act is. And
Today is that the word sexual should have been in there, right?
one of the arguments. And at base, if the jury is not instructed on that, that it has a sexual component, which the state has argued in its brief very persuasively that it's questionable whether really that there's no requirement that it has to have a sexual component given the change in the statute. So we'd argue that it's preserved because in the district court had the opportunity to pass on that issue, ruled against the defense. And on appeal, we've touched upon it, the state in its brief also addresses that argument and correctly cites State v. Mesh, which addresses the issue of whether or not.
They do, they cite Mesh, but nowhere in the blue brief, the gray brief, or the further review application does the defense ever talk about Mesh, do they?
No, but, in the application for further review, in the alternative, we've asserted that the jurors need to be instructed on what illegal act the state is wanting the jury to consider.
Does it matter what that illegal act is? If it doesn't have to be sexual, can it be any of the things that the prosecutor mentioned in closing? Wouldn't all of those work?
Well, I would focus on Mesh because it talks about how even though burglary, that statute doesn't say what category of offenses would qualify as, when you're committing a burglary, you're entering with the intent to commit an offense. That Mesh says that the jurors should be instructed on it, and also the state should charge it as such to give the jury an opportunity to consider.
As I read it, as long as it's the type of act that can be committed upon another person, so not kind of personal drug use or something, but something that you can do to someone else, that it would be okay. Why is that not right?
Why is that the lack of a specific crime? I would analogize it to the other crimes. In looking at the model instructions, there are other crimes, for example, felony murder, solicitation, conspiracy, assault while committing a forcible felony. When we look at those model instructions, they actually say insert, specify the crime. And also, they've also indicated in some instances, particularly with the, assault while participating felony, the bar recommends that the jurors be given the elements of the crime that the state is alleging.
Clarify your argument here, which may be a little bit different than a different district court, but not a lot. You're not saying it has to be a sex abuse crime here. You're just saying some crime needs to be specified and then put into the instruction.
And really,
About that. So, no. It seems like we usually say an instruction is fine if it correctly states the law, right? And I think this instruction does correctly state the law, which is the statute makes it an illegal act to attempt to entice to do an illegal act upon another under the age of 16. So it's technically correct, and you're not making a constitutional argument, right? So other than that you think there could be a better instruction, is this instruction actually wrong?
it's wrong insofar as, here's the problem with that, because when the jury is given a legal act, that doesn't, in and of itself, the jury doesn't know what statute, what statutory violation, what crime. I mean, what lay people think is bad or is a crime may not necessarily meet the statutory definition of, under Iowa code. So that's a problem right there. Granted, I think that
Is a problem, but it's a problem that's codified. I mean, the crime is committing and attempting to entice and then committing an illegal act, which is what the jury instruction said. And if you're not making a constitutional argument that there must be some specificity for this to be permissible, I guess I'm not seeing the error necessarily.
But if you would look at, the other crimes that I've talked about and, in the jury instructions there with the robbery, felony murder, with the involuntary manslaughter, the public offense, again, those statutes do not specify exactly.
Do it differently. And they seem to be okay with that. There's not a constitutional issue. So just because our state does it differently with respect to burglary, I'm not sure that we necessarily have to have more specificity here.
Would apply to, if mesh applies to other crimes, then it should apply in this crime as well, because the similarities are that the statute doesn't name the crime. And again, go ahead.
Troubled by what was argued at district court and what is in your brief. Your brief says, nevertheless, Brown argues that the jury should have been further instructed that an illegal act means, quote, an unlawful sexual act upon or with the alleged victim. And then you repeat that and says the jury should have thus been instructed that an illegal act means an unlawful sexual act upon or with the alleged victim. Seems to me in the briefing you're saying you have to have that word sexual in there. And yet at the district court, I do agree with probably a broader argument was made. But correct me if I'm wrong, isn't the brief focused on we should have, or the jury should have been told a sexual act means illegal?
Really, but the issue is, and the parties talk about this too, is that the defense wants the state to narrow their focus. And again,
Asking us to do in your brief, you've said several times it should have said illegal sexual act. Just am I wrong on that? Isn't that what you're asking for?
that is correct. But again, what's the essence of it? The essence is the jury was not instructed on a crime, least of all a crime that had a sexual component.
To me to be making a reasonable point. That is, the argument below that was made below by trial counsel was, you need illegal act leaves the jury at sea. They don't know the law, so you need to tell the jury what's the illegal act that the defendant was attempting to, was specifically intending to commit. And that's one argument. The argument you're making here seems to, at least in your brief, as opposed to maybe in your argument today, seems to be that it has to be a sex act, that it has to be an intent to commit a sex act. And that argument I struggle with a little bit, particularly because 710.104 provides that the defendant doesn't have to register as a sex offender unless the illegal act was sexually motivated, which makes it sound like clearly the illegal act doesn't have to be a sex act. So, I mean, what precisely is the argument you're making here to us today?
Well, the argument is that, initially as it was raised that the jury wasn't told what the act is. Secondly, and we went further on appeal, that there was no, it should have some sexual component to it. Again,
Two, when you say it has to have a sexual component, does that just kind of obliterate the statute 710.10 sub 2? I mean, that's the one that comes right out and says commit an illegal sex act.
exactly. Like I said, I do acknowledge that the state has, that has brought up the legislative argument that was also explained to the court. Explained to the court explained to the parties about that. But regardless, in arguing it before the Court of Appeals, they didn't address, they just addressed that this is a correct statement of the law. So, and for further review, part of it, maybe, wasn't phrased, in the briefing, initial briefing, but the essence of it is that they weren't told what act. And that's really the crux of the problem that, we see on appeal here is that there's no guidance.
It's instructed as a specific intent crime, and our cases seem to treat it like that. Would it matter if this specific subsection were more of a general intent crime? Meaning the statute means something like this: the defendant attempted to entice the minor for no legitimate purpose, or with no legitimate purpose. If that's really kind of what the statute meant, would that be okay?
The statute, that would not, like I said, I think implicit in the statute is that, the state has the burden to prove or offer theories of prosecution as far as what is it they're defending against, as far as what crime. And in this case, the state did not offer anything concrete, just in fact, in closing arguments, the prosecutor basically just said, it's up to probably in the jury discussion or jury selection or jury instruction discussions, they said it's up to the jury to decide what is the illegal act. And the problem here is that what the jury thinks is illegal may not statutorily match up. And as I've said, when the bar, the committee offered these model instructions, I think that they did contemplate, perhaps this is, that's what the state would do, would offer specific alternatives. They would be plugged into the jury instructions, just as in the other offenses that I've named.
Instructions. They did, I think it was number 100.12 is the one they used. And in the comment of that uniform and jury instruction, they do cite mesh, and it's relied heavily upon by the state. But I said earlier, it's not argued anywhere in any of your briefing, is it, other than what you're saying today?
But at the same time, I think that I would just focus on that's what the issue is here. That's what the problem is.
See the evidence, because we're getting down on time here. So you have a chance to say something before the state responds. When you said there was no evidence presented, I thought that was curious that when he was questioned by the police, he made a comment that, well, I thought she was 18. Isn't that an indicator that the jury could rely upon? Pretty strong. I mean, if he was just going to give her a ride or give her a lollipop, everybody knows you don't have to be 18 for that. Doesn't that indicate something that the jury could hang their hat on for an illegal act? Why would it matter if she's 18 or not?
Well, again, that asks the jury to actually, as the prosecution stated in its closing argument, it's just basically there's nothing good can come of this. And again, on appeal, as with the attorneys, the judges, there is nothing. There's nothing to link that what's bad to what's an illegal, and they do. It would not. It wouldn't be a fair trial here if what the jury decided on was the bad act is the equivalent of an illegal act. And you pointed out the body cam video. The officer towards the end, maybe 3-minute mark, makes the comment that it's not illegal, but it's not right. And again, in reviewing, that video, a large portion of the discussion is the officer trying to get Mr. Brown to admit to wrongdoing and to just have a discussion, shaming him that you shouldn't be talking to young girls. You're a 70-year-old man talking to a young girl in public. You shouldn't be doing that. Again, that is the tone of the interaction.
Than that, wasn't there also, according to her testimony, which the jury could have found believable, he was stalking her around the store. He was following her. She was trying to ditch him 3 times. She tried to go to the payout on the self-payout and couldn't get through it without him bugging her. There was way more than just him talking. Her tummy siren obviously was going off. So wasn't there more evidence than just talking? And I forgot to mention the car pulling up afterwards and saying, "Hey, you want a ride?"
All that shows is, okay, so what specific illegal act, what bad thing was Mr. Brown alleged to have committed? And that it is up to the state has a burden, again, to narrow down what their theory of prosecution is for that type of case. And again, we don't, we point out those facts, but at the same time, there was nothing else. We don't have anything that we see in the other enticement cases, for example, bribery, any kind of assertion of authority or control, or, he's an older guy, asserting, like, get in the car. It was a simple offer, which she said no, and then he drove away. That's also something to consider within this mix of, circumstantial evidence about his intent, which we know is very difficult to prove with, there's really a lot of cases not allowed direct evidence to say that.
Come back on round 2. Mr. Sloven?
Thank you, Madam Chief Justice, Counsel. Good morning. Louis Sloven. I attended Valley High School in West Des Moines, go Tigers, also by way of Central Academy in Des Moines, and I'm just going to guess the Sig Figs. Probably not an official mascot, but anyway, may it please the court. Madam Chief Justice, I think you're correctly identifying that the challenge that's raised in the briefing on appeal is not the challenge to the instructions that was argued below, which was failure to specify particular illegal acts. And you can tell that just by reading the briefing. Another easy way to tell that is because the ask in the brief on appeal was, you should have had the instructions just say, intent to perform an illegal sexual act upon her, and didn't even ask.
I'm going to jump past that because I think that one, to me, is a much simpler one. How come, Mr. Sloven, when the defendant said, "Can you give us an idea in the instructions of what are you talking about?" What's the big deal? You really want a jury to leave it up to their own devices to figure out what is legal and what is illegal, whether, even if it's, take the sexual component out. You're defining the word attempt. That seems like a really simple word. And when somebody asks for the word illegal crime act to be defined, no. Help me understand how that wasn't perhaps maybe incorrect by the court.
Well, part of this is that to the extent that there's a problem, it's baked into the statute deliberately. The statute specifies intent to commit an illegal act. The legislature is presumably aware of mesh and the dichotomy it draws. Choose this language to do this.
From, sort of the omniscient legislature that reads all of our cases. I don't even read all of our cases. And I mean, Mesh was saying that you had it in the burglary context, you have to specify the felony, and then it was just distinguishing some cases in other states that said no based on a wording difference. But I think it's a bit of a reach to draw from that when there's a different statute that says intent to commit an illegal act, you shouldn't define the illegal act for the jury. The jury doesn't know what's illegal and what's legal. If they do, then I wasted 3 years in law school. I didn't need it. I mean,
part of it is that Mesh would have been a much shorter opinion if there weren't a need to consider the differences between these two different kinds of language. And the language that's used in 710.10.4 here describes a general criminal intent, not a specific intent to commit a criminal offense within a certain category, and that's the difference. Now, the universe of acts that are illegal and can be committed upon another person is vast, and the state isn't required to narrow down
Here they had some ideas in mind. They could have, wouldn't it have been more fair to the defendant instead of just allowing the jury to say, oh, he's up to no good, therefore he's guilty, to specify the illegal act? We've got the stand your ground cases, which, like Ellison, which we decided much more recently than Mesh. And in Ellison, we said in order that the illegal activity, which is part of the stand your ground justification defense, that illegal activity should be defined for the jury. You shouldn't just allow the jury to speculate on what's legal and what's illegal. So why doesn't that rationale apply here?
Part of it is that the jury instructions correctly stated the law. We could optimize them further, and maybe some more advisory guidance would be good, but there's no way to say that these instructions didn't correctly state the law.
But that doesn't mean that a jury instruction should just quote the statute. I mean, yeah, that correctly states the law, but a jury instruction that asks the jury to decide what's legal and what's illegal, that seems to me that's not a jury instruction that's appropriate, is it?
The other thing to consider is that you're saying, and I agree with you, that lay jurors don't act with perfect knowledge of what is legal and illegal. Neither do defendants, neither did Mr. Brown. What we're describing is a general criminal intent, kind of equivalent to the way that we think about malice aforethought, an intent to do something unlawful. And the knowledge of its lawfulness is not...
It says, with the intent to commit an illegal act. That doesn't sound like a general criminal intent. That sounds like a specific intent to commit a specific illegal act. Why not tell the jury what's the illegal act?
That the state is allowed to allege all of them in the alternative, and without being held to a particular...
If they think that there's two or three that the defendant that there's sufficient evidence that there's two or three possibilities, they can include all of them in the instruction, but at least include some guidance, right?
I agree that would give the jury more guidance. It would, I mean, the jury instructions are already correct. At best, what you're describing is that the court could give instructions that say an illegal act includes but is not limited to, and then describing particular acts that the state and the court... Yeah, well, easy until you start getting a long list of potential illegal...
Using this to his advantage, he or she, I can't remember if it's a man or woman, he or she argued throughout, could be kidnapping, could be this, could be that. So I give you the defense at their closing could have addressed A, B, and C. Maybe the prosecutor said it could have been A, it could have been B, it could have been C. Defense could have said, yeah, oh, let me tell you about A, B, and C. Okay, it's been addressed. However, rebuttal, I saw on the record, he threw in D. He threw in robbery. He threw in a crime that defense has no opportunity, even by words, let alone instructions. So it just seems to me that that's kind of loosey-goosey for the state to be able to just throw some out and have nothing for the jury to rely on as far as guidance.
So I think that the way to ameliorate this, first of all, an objection to a new theory of liability that was not argued before might have been available. But if the defense, and the one objection that I saw from the defense about a thing that may not have been illegal, that the jury may have believed was illegal, was giving a stranger a ride somewhere. If that's the case, the defense can ask for an instruction that specifies it is not an illegal act to, and then particular acts. Now, the jury, and Justice McDermott, I believe you pointed out that unlike burglary, which is a felony, and jurors do not have the knowledge to know what is and is not a felony, this is a more open universe of illegal acts with a common sense. The only factor that could limit it is a common sense understanding of what acts can be committed upon someone. And the acts that the state was arguing are all acts that illegal acts that it would have been entitled to a definition of if the court had decided to give definitions for acts that were supported by the evidence. Assault, kidnapping, false imprisonment, sexual abuse, primarily sexual abuse, because the evidence in this case most strongly militated towards intent to commit some sort of a sex act with the victim.
Additional instruction that said an illegal act includes the following. Wouldn't there also have to be an instruction where the jury found the elements of those offenses as well?
The jury would have to find intent to commit an act that satisfied those elements. But here, we're dealing with an act.
By the elements of the other acts, and the jury would have to at least find those as well, right?
No, but we're in the attempt realm, so they wouldn't have to find those elements were met. They would only have to find an intent to commit them, right?
To be identified to further define the illegal act that's identified in the illegal act instruction.
Now, you say, Chief Justice, isn't this easy? Well, it's easy when you have one or two illegal acts. The problem is that the statute allows the state to allege all possibly illegal acts in the alternative.
Limited to, that's what that means. I mean,
50 pages long, and we scratched the surface.
We've just been down the road in the last few years in stand your ground, and I'm not hearing the state saying this is impossible. I mean, we've said the same thing in our stand your ground cases. Don't tell the jury the defendant can't rely on the stand your ground defense if they were engaged in illegal activity. Tell them what the alleged illegal activity is.
That makes more sense in the context of illegal activity that satisfies the Lorenzo-Balthazar test of a nexus to the act of purported self-defense, where there's that limiting factor that then requires the state to identify illegal activity that satisfies that legal test. Here, it's just a general criminal intent to commit an illegal act, and the whole, right. Now, I want to touch on harmless error too, because Justice McDermott, I think you're right that all of the theories that were mentioned by the state would have been supported by sufficient evidence, and we're clear from the evidence here. The state can allege all of them in the alternative, so that if a juror says, well, I know that it had to be either intent to kidnap, intent to assault, or intent to commit a sex act, I just can't choose which, state's entitled to a conviction from that juror on those findings. Now, the jury here, or
The difficulty of applying harmless error on a sufficiency challenge when the elements weren't included in the instruction. And it seems, I mean, I know the U.S. Supreme Court's been kind of divided on this issue, but that seems problematic, right? To say that even though the jury didn't make a finding here and they weren't asked to make a finding here, we can affirm the conviction because we think there was sufficient evidence, which is, you know, kind of like a directed verdict motion in criminal cases. Yeah.
distinction. I'm not saying harmless error on sufficiency of the evidence. If the evidence is not sufficient, don't find harmless error. What I'm saying, but, and I want to build on.
Jury instruction based on overwhelming evidence of guilt, that still seems a problem to me if there's not an element in the jury instruction.
I think it's a different issue when you're talking about omission of an element entirely, where the jury made no finding, versus definition of an element that we want to encourage courts in the future to give more. But you can't look at this and say that the jury didn't make a finding beyond a reasonable doubt that he intended to commit an illegal act upon her. They made that finding. They were urged to. The instructions required that finding. And in fact, that was the focus of all of the argument that was being made. The defense did not argue that here are some ways that the, various, by a technicality, some acts that the prosecution is talking about might not have been illegal. The defense theory was they haven't disproven a good Samaritan intent. The battle was very clearly joined, and the jury, in rendering this verdict, found beyond a reasonable doubt that that was not his intent. His intent was to do something illegal to her. They made the core finding as required by that element.
Argument. Am I correct that questions were asked? Must have been during the interview with the cops because the defendant did not testify, correct? Okay, so it must have been during the interview. Aren't I correct that they said, was she in trouble? Did she ask for help, or did they ask that of the victim? There were questions like, did you ask for help, or did she ask for help? Was she lost? Was she hurt? And all the answers were no. Do you remember?
The defendant did not ask those questions to her. She was asked those questions on cross-examination by the defense attorney. Did you talk to a security guard? Did you call 911? Now, she called her parents in the moment, put them on FaceTime. Calling her mom is kind of like calling 911 because her mom is a 911 dispatcher. It just meant that the call wasn't recorded, annoyingly. But you understand why she did that. Look at the statements that he makes when he is under the impression that the officer has viewed the video from the Jewel Osco, that That's, I think, the main reason why he doesn't attempt to claim that he thought that she was in trouble and that's why they interacted. Because he is aware that the video footage, should it exist, would make that untenable, and that he has to make the jury found untenable claim that he thought that she was 18. Otherwise, there's no plausible explanation for his conduct. He knows that her experience of it and what's shown on the video shows an intent to strike up a conversation that is, the kind of conversation that you would expect if you were trying to pick someone up.
If she's not 18, yeah, it would not be appropriate for me to have asked her if she wanted to ride.
Yeah, I don't know that that was limited to the ask for a ride. I think that that was discussing his entire course of conduct, that it wouldn't be appropriate if she was under 18. Now, the jury got to see for themselves. She was, at the time, just turned 13. At the time of trial, she was 10 months older than that. The jury got to see for themselves, and if the jury finds that it would have been clear to him that she wasn't 18, they can infer that he was lying about what happened and lying about that there was no plausible non-criminal intent that he could claim. And he knew that in his conversation with the officer, which is why the best he could do is to say, I thought she was 18.
Times during argument, you've mentioned that this element of an illegal act was more like a general intent crime, like having malice aforethought. But at least as is instructed here and historically treated, it's been treated as a specific intent crime, and you're not deviating from that.
What I'm saying is attempted enticement, as defined here, is a specific intent crime, enticing with the intent to commit an act that is later done with general criminal intent. So specific intent to commit an act, and that act later does not require any specific intent itself. It is a general criminal act.
Not have to agree on what the illegal act is, correct?
The statute is written that way, and that's consistent with Iowa case law and alternative means of committing the same crime.
There's a category where this person is a good Samaritan. There's a category where he's intending to commit a crime. And then there might be a gray area where he's intending to behave in a way that is weird, inappropriate, but might not be criminal. Isn't there a middle category that a juror could land on?
Yeah, I'm out of time if I can respond to the question. Thank you. Really not in this case. And the reason why is because any sex act with this 13-year-old would be a criminal act. If there is an intent to engage in any sort of a sex act or, entice further, advance it towards engaging in a sex act, right? As long as there is the intent to develop and enable that later sex act, that is an intent to commit a general criminal act. And the defense seems to acknowledge and recognize this in, arguing that this is a good Samaritan intent, not arguing that this is creepy but not illegal.
But you would agree that might be it. People sometimes act in a creepy but not illegal way, but that's kind of a hard argument to sell to a jury as opposed to saying it's totally innocent. I mean, there are at least, maybe not in this case, but there are 3 different possibilities sometimes for conduct that seems socially highly inappropriate, right?
So I think that's generally true. The problem is that once you take out, the thing that differentiates your middle category is the lack of intent to consummate, the lack of intent to accomplish an act upon, right? The sort of like voyeuristic look but don't touch, sort of what the guy in Quinn says his intent was, that he just wanted to make eye contact and then use that later for fantasizing. But once it becomes clear that there's an intent to commit an act upon, now that middle category is gone. And that's the finding that the jury was asked to make.
Evidence that shows in the state's view the evidence was sufficient to sustain the conviction.
The actus reus of attempt to entice is accomplished at the moment where he waits in the parking lot or nearby, pulls up and asks, do you need a ride, inviting her into the car. That's the attempted that could almost count as completed enticement, but you don't need to decide that because this was charged as attempt. It's at least attempted enticement. The specific intent is established by inference from all of the other facts in the case. From the initial encounter where he stares at her, then follows her 2 aisles over, looks her up and down, starts asking her questions, follows her through the store, waits at the self-checkout for her, and she's like delaying to try to, wait for him to complete his business and get out. That's not gonna happen because his business is following her. And then she gets out on the street, he comes up and he's waiting for her. That's why I put Lefebvre in that notice of additional authorities, because waiting can be part of the actus reus of attempt. It's also indicative of that specific intent to accomplish something. And then the admissions that he makes to the officer later, specifically the lack of any claim of pro-social intent. He never once says anything to suggest that he thought that she needed help. Instead, it's about what he wanted from her, and his view of her as pretty. Some older petite ladies look young, and acknowledging that his interest in her would have been inappropriate if she were 18, but of course she was very obviously not. So all of that together, we're very comfortable inferring specific intent from a collection of facts and circumstances. Thank you. Oh, please.
If I were the trial court judge and you were the prosecutor and I was persuaded by her argument, and I'd say, what do you want the instruction to say? We're going to talk more about it. What could it say that wouldn't be so far 100 pages, 200 pages? What could it say at a bare minimum to give a jury an idea of what is an illegal act?
It would have to use included but not limited to. It would have to define the various illegal acts that we think are real possibilities and potentially supported by the evidence, define them each in the alternative, clarify that you don't need to find those elements are actually satisfied. All you need to find is an intent to commit an act that would satisfy those elements if the facts are as the defendant intended or believed them to be. And then it would have to, again, specify that the jury doesn't need to agree on which one, but has to find, and may find that they are convinced beyond a reasonable doubt that he intended to commit an illegal act that is not listed. And that's kind of one of my big problems with the idea that the jury needs some guidance as to what's an illegal act, is because as the law is written, they're free to decide that he intended to commit an illegal act upon her. That is not specified, that is not urged. They're free to make that conclusion.
Burglary, this is not such a burden on the state. The state gets burglary convictions. Why do you think that this is so hard?
Part of it is that it's not just that it's hard, it's also that it's unnecessary. It's that the universe is wider, necessitating more alternative instructions. It's that the burglary has been written in a way, and the legislature wrote this in a way, indicating a choice to take 2 divergent paths. And it's also that once the person's inside the house, that helps narrow down their intent in a way that makes a proliferating universe of alternatives less of a factor to worry about. Whereas here we're drawing inferences of a much wider possible universe of potential. Now, in practice, this ends up being a lot narrower because of his admissions and because of common sense about why a 70-year-old is going to be interested in a 13-year-old girl. But the potential here is for these multiplying alternative instructions that stretch on pages in a way that we don't have with burglary.
I know you just thought of this potential jury instruction on the fly, but you said included but not limited to. That seems to me that it doesn't solve the problem. Okay, so I mean, to be correct and to solve the problem that the defendants raised, it just needs to be illegal act means, and then the state's gonna have to pick a horse or several horses. But if you leave it open-ended, isn't that exactly where we are now? The whole universe of criminal activity?
Is inherent in any jury instruction that correctly states the law. And that's just how the law is written, that any illegal action can satisfy. And the jury gets to make findings about.
Well, but the court has to find that there's evidentiary support for it, whatever it is. And presumably the state can say there's support for A, B, C, D. The things they haven't thought of, isn't that enough?
The problem is that if a juror says, I don't believe A, B, C, D that the state has alleged, I think it's an additional thing, E through Z, that is illegal but is not specified by the state. That person should convict, and the instructions should be written in a way that leads that juror to convict. And if they're not, they misstate the law.
And again, in burglary, I mean, I'm sorry that we taking, but you're, I mean, these dialogues with both lawyers are helpful to us in deciding the case, or at least to me. But why, in a burglary case, if the state's theory is that the defendant broke into the house in order to commit a theft, then that's what will be, or commit a robbery or whatever, then that's what'll be the state will specify. A juror doesn't get to then make a conviction because they think, based on their own personal view of the evidence, that the defendant may have intended to commit a sexual assault that's not specified in the instructions. And that we don't view that as a problem. So why is it a problem here?
You that it's interesting and worth talking about. That's why I addressed it in my brief, even though it wasn't raised by the brief, and so I don't think is a ground on which we can grant relief here. But to answer your question, what you're describing, like, you're zeroing in on the very narrow universe of potential felony offenses that that can be committed, that you can commit a burglary with an intent to commit, whereas. And that's part of what makes it more amenable. The other thing is that we're uncomfortable with jurors applying lay knowledge to determine whether an event, something they think is illegal, qualifies as a felony. And that concern isn't present here. And that's what you see in all the cases that Mesh describes that cite all of these other burglary statutes, that because the legislature specified any crime, we leave it open and we don't require an instruction or a specific allegation of a particular crime that the defendant intended to commit. It's satisfied as long as there is a general criminal intent, and you don't need to define the elements of any of the multifarious crimes that fit that much broader category.
So is the state's argument he was up to no good enough?
No. The argument is you have we still define out the elements of what attempted enticement is. It has to be an actus reus attempt, overt act evincing a purpose to entice, with specific intent to commit some sort of unlawful, illegal act upon her. And yes, that is a subset of he's up to no good, but is it the specific area of up to no good that violates the statute? And the statute is written in such a way that it is intended to be triggered upon that finding. Thank you.
Ms. Jennisch.
Thank you. I wanted to take the opportunity to address the sufficiency argument, which is related to the idea of that the state hadn't proved he had the intent to commit an illegal act. And as Justice Christensen pointed out, that's essentially what the prosecution's theory was. He was up to no good. Actually, in closing, the prosecutor hammered that. And the theme of this case is pretty much stranger danger because, starting with jury selection, the prosecution goes through all the prospective jurors, many, I should say. Again, what is your idea of stranger danger? Do you have children? What does that mean? Again, this theme was brought up, in closing argument. And again, in this case, what do we have? We just have a 70-year-old man. He is making a 13-year-old feeling uncomfortable. Evidence, he's following her in the store, but, according to the testimony, essentially the conversation was pleasantries. Hi, what's your name? He's trying to, one could view that he's just being friendly.
That girl, she did all the right stuff. And she put her mom, and I think, by the way, any mom is 911, not just if you're a dispatcher. But anyway, but my point is, do we have to wait for something to actually cross the line and become a crime? And this is an attempt to entice. So the up to no good, and the creepy, all of that, isn't a lot of the evidence that supports all of that. We don't have to have evidence that actually shows those things happened, just that it's going in that direction, correct?
There's no evidence, any additional evidence. Again, we're relying on inferences based on, circumstantial evidence. And again, that's part of, part of the issue here is that the jury doesn't have anything beyond, him offering the ride. She declines. He drives away. She's feeling uncomfortable, and scared, that's not an issue whether or not, she was justified in feeling that way. Again, she did the right thing, called her mother. But in a case like this, when we're talking about what's a rational inference from, these limited facts, and, our
Practical concern that I think the state is raising in a burglary case or even in the self-defense context, there's really a narrow universe of things that you could logically infer that somebody is doing under those circumstances. Whereas here, he's approaching this young girl. He admits it'd be inappropriate if she were under the age of 18. But there's a whole universe of things, of illegal acts that he could have committed upon her. How is that instructed in a practical way that doesn't just make the jury instruction overwhelming?
Oh, I'm sorry, are you asking for a proposed instruction?
What does that instruction look like? Does the state have to pick a theory, 2 or 3 theories? Mr. Sloven said illegal act means these things, limited, including but not limited to. But that doesn't seem to solve your issue, which still leaves the whole universe of criminal activity available to support the conviction. So how does this get instructed?
I think that, we just have to look at the other offenses that I mentioned, that talk about, when it involves an intent to commit another crime. And in those instances, the parties, the court, when they're talking about instructions, the model instructions say, name the crime, name the act. And as I said, in
What acts would you have wanted the state or the court to instruct on?
Well, at base, I think it's just that the state should offer one alternative, multiple alternatives. They do that in other cases.
One that's asking for this instruction, the state has offered what the model instruction is, and you're asking for a different instruction. It seems like you should be the one to at least provide something. So what would that instruction have looked like? I think originally maybe there was an...
Name the offense, and also, but also in addition to that, have a separate instruction defining the elements of that offense. That would make things a lot clearer, and that's what in other cases is done. As I said, in conspiracy and.
The jury should have been instructed that, it could have been with the intent to kidnap. Here are the elements of kidnap. It might have been a sexual assault. Here are the elements of that. It might have been just a regular assault. Here's that. It might have been to harass. Here's that. It might have, false arrest. Here's that. Is that what you're envisioning that these instructions should have looked like?
Ideally, that's a place to start, at least, the naming of it.
Of that, and I think I am persuaded now, or at least concerned, by giving a few examples, you're going to make a juror, and I've been around a lot of juries, you're going to make a juror think, well, I do not see A, B, C, or D. And I just wrote down some real quick things that, in my experience as a juvenile judge, I could think of why an adult would want a little kid like that. Child porn. Can you help me go rob a bank together? You'd be a great decoy. Contributing to the delinquency of minor. Maybe he wants to just pull her out and not have her go to school, whatever it may be. There is a lot of stuff out there that somebody could use a kid for to pull off. And I'm nervous about naming a few. I think we've all talked about the majority of what we think it probably was. But does that close the door for anything else? And the legislature said an illegal act. They didn't say these acts, any illegal act. So isn't that a problem by saying some, that you're going to give the jury the message that they can ignore everything else?
I think that I would just go back to the problem with the instruction in this particular case. I know we can also look broadly in terms of stranger danger here, but I think I think it's also, I wanted to point out too, we're all thinking maybe something sexual. Is that,
So,
but the court at sentencing found that they was not sexually motivated.
so
The universe of offenses.
district court here finds that under the second part of 710.10 sub 4, that that the illegal act was not sexually motivated such that this defendant has to register. Does that mean that the district court should have instructed, among the list of things that the prosecutor said here, one of them was sex abuse? Should the court have instructed that there wasn't evidentiary support for that issue? And therefore, if that's the illegal activity that the jury had in mind, that they should acquit?
So the question is, should the judge sua sponte?
So,
By either, it wasn't even part of the discussion. So, I think that
think through how this instruction would look, because I think there has to be evidentiary support in the record to support whatever illegal activity the jury might convict on, right? And so does the court have to go through and say, I don't find evidentiary support for these particular crimes, but maybe for these crimes, for assault, for harassment, for some of the other ones, for kidnapping?
So I think that, again, in flipping through the model instructions, that's what the parties are, told. If alternative A, B is not met, then it's not instructed. I think, in other situations, the court has the discretion, or, if the parties argue, obviously, but if the evidence does not support the submission of those, of that alternative, then they shouldn't be submitted to the jury. And I would also add to, yes, just me, you have a question? Go ahead. No, I just wanted to also add, this court before has talked about, the inflammatory stranger danger, and this was drilled in, starting from jury selection, and the prosecution basically said there could be no good reason for him, 7-year-old, to offer her a ride. But what struck me is that how short a time the jury took to deliberate. They were given the case at 4:24 in the afternoon. They come back with a verdict, finding him guilty. And as we talked about, this nebulous idea, what is an illegal act? The fear is that really it's not the jury's job to find whatever nebulous illegal act qualifies. And really, there was discussion about, there's third category of behaviors.
I will interrupt you now. So anyway, I just have one sort of narrow record question, since I see you're about out of time. In your brief, in the error preservation discussion, there's reference to the district court rejecting proposed language, and I wonder if that might be a typo or if I'm just missing something. I did see some suggested or some proposed instructions, but I don't think those proposed instructions get brought into the actual objection to the jury instruction.
The proposed instructions that, as memory serves, that are filed in the court? Yes.
Those instructions, and sometimes I can't, it's harder to see who filed what.
Parties and whether or not those are the actual ones that were.
I don't see is just sort of comparing with the brief. The brief is talking about the district court rejecting particular language, and I just don't think that at the jury instruction objection hearing that there was actually like the defendant saying, you need to give X, Y, and Z. It said that the defendant was saying, why aren't you giving A through Z or whatever, right? Or whatever you want to give. Is that am I making sense? What? Okay.
Again, I humbly admit that, it wasn't, artfully stated or argued or whatever, but I think that we've just identified what the problem is here. And so at the district court level.
Questions for you on this point. I promise I'll be done. Does it matter if the defendant intends to do something that he thinks is an illegal act, but it's actually not?
Does it matter? I don't, again, it's racking my brain with this hypothetical, but, is it?
It seems like.
Well, I guess the statute leaves it unclear. And.
For example, let's say he wanted to kiss her neck. That would be illegal because she's a minor. And then if you look at like the indecent contact with a child statute, that actually doesn't meet the elements of the offense. Is that enough to sustain a conviction or not?
Evidence of what he thought was illegal or not? I think that I guess what he thought would be illegal with that, I think that also, I think that there could be argument that it would be relevant because, again, that would be objectively, speaking to what would a reasonable person in that position, what would they find to be an illegal act? Again, I really don't have a very good.
I would feel assaulted at that moment.
That's why it's, we're not saying that, he may have, there may be, some people may interpret it as assaultive. But again, the question is, in the context of this crime, what is it aimed towards? We've had other cases, similar icky, behavior, what we, this court has called, perhaps not appropriate but at the same time, for the purposes of the statute issue, it's not illegal. And that is not to say that has nothing, bearing on what, may be considered in society.
Being creepy a crime, huh? All right, I think we're done. Thank you. All right, the case of State versus Brown is hereby submitted, and we'll take a brief pause as the attorneys prepare for our next oral argument, State versus Porter.